Hey, everybody, welcome. Boy, do I have a lot I want to talk about tonight. There's a bunch of stuff I want to talk about, but welcome, everybody. And we're just going to let the chat catch up a little bit. And so I'm just going to give you a rundown of a few of the things that I want to talk about. There was a pretrial hearing, a status conference on the Daybell case. And so I want to give you an update on that, on Chad's case. Somebody asked me about giving an update on the D. Warner case, so I'm going to do that. There's a lot happening in the YNW Melly case, which had a hung jury and is now going back for retrial. And there's some big things happening in that case. And Ferrier, that's the case where the father is accused of having abused the son by locking him in a room in a garage. And so we'll talk a little bit about that because it went to closing arguments today. And then Ellen Greenberg, which is a case where a death was ruled a suicide, even though it clearly was not a suicide. We've got a few developments in the Markel Adelson case and a couple of interesting gee whizzes about Rex Heuermann. And somebody asked me to talk about Jonathan. I'm not sure whether it's Quillis or Quiles, so I will talk about that. And then finally, we're going to talk about Karen Reed and John O'Keefe, which is a really interesting case, which is coming up for trial next March, having to do with a former police officer. So we have lots to talk about tonight. And I do want to just sort of let everybody catch up. While I do that, I want to tell you about a couple things that we're going to want to talk about. So one of them is, and my flyer is covered up by our banners, but this is the raffle for the True Crime Quilt Guild quilt that you see over my head behind me. This is a quilt that we did for our Quilt Along project while we were waiting for Lori's trial. And this is my version of it. We also have a lot of folks who did their own version of it, but this one we're going to raffle off. So you might be able to see down in the kind of in the second block up, I did a little hand embroidery. That's my logo. And so we're going to raffle this off. The raffle starts today and will end next month on November. I realize my flyer is wrong. It is November 22nd. Which is a Wednesday night. We will draw the winner and I will send you the quilt. So to enter, there is a link at the bottom of this flyer. It's also a link that you will find in our show notes. And if you go to that link, it will ask you for a sliding scale donation. And in return for that donation, you get, for every dollar you spend, you get entered in the raffle. You get a raffle ticket. And on the 22nd of November, we'll draw the winner and get it on its way to its new home. So that is super exciting. The other thing I want to remind everybody about is that my friend Mandy Matney, who has the Murdoch Murders podcast, also has, which is now called True Sunlight, also has a podcast with Eric Bland, who is a lawyer for some of the victims in the case, called Cup of Justice. She has written a book. The book is due out the first part of November. I think it's November 11th. I've pre-ordered my copy, and I just want everybody to know that that is out there. It is something of a memoir as well as telling the Murdoch story. So it looks like it's going to be really interesting. I heard Mandy read a couple of excerpts, and it sounds like it's going to be great. So I love to support other creators, especially authors. And the reason for that is that pre-orders are so important for authors, because it's the pre-orders that give the publishers an idea of how the book is going to do in sales. So we always ask for folks to pre-order books, including I'll be asking the same thing of mine when pre-sales become available. We hope that that is going to happen at CRIMECON in May of next year. I'm busy at work on the book, and getting some chapters out for some preliminary readers, just to make sure that I'm sort of on the right track and making sense. So I feel like we're making some good forward progress in it. Arizona, thank you so much for your donation for Michelle. For those of you who might not have caught our last show last week, Michelle is confronting some pretty serious health problems. She is going to be starting chemotherapy on Tuesday for blood cancer. And so we are sending her all our support. Those of you who know Michelle know that she's very devoted to our true crime community. And so, and those of you who know me and have been following for a while know that any of our donations in the form of super chats or PayPal donations go directly to Michelle. So if you can help Michelle out, please do so, because I know that she appreciates it more than she can tell you. So I think that without any further ado, whoops, rearranging my stuff here. Let's get started and dig into some of the cases that y'all have been asking about. So first of all, I want to talk about Dee Warner, because I did get a request to give an update on the Dee Warner case. This is a really interesting case. Dee Warner disappeared. Her body has never been found, but they believe that her husband, Dale, is responsible for her death. Her family, her children, have asked the court to declare her dead so that they can file a wrongful death suit against Dale. One of the problems has been that he has been in charge of probating her estate, which apparently is fairly sizable. And he's been dissipating assets, selling things, selling property. And so the family would very much like to get him out of there by getting a judgment saying that that he's responsible for her death. In the meantime, he keeps defying the probate court when they ask for records and orders, because Dee's family is contesting the probate. And so he's currently in jail. He was just sentenced to 93 days in jail for contempt on the 23rd of September. He was sentenced to 93 days in jail for contempt for not complying with the court's or the probate court's orders to produce records having to do with Dee's assets and property. So you have to give her family a lot of credit. They have stayed in the fight. They have been adamant that they believe that he is responsible, and they have continued to press to hold him responsible. At this point, there has not been enough evidence to charge him with her death. So the family is having to go off of to pursue it civilly in a wrongful death case. But they can't sue him for wrongful death until the court declares that she's dead. So we're waiting to hear what happens on that case, hoping that at some point what really happened to Dee will be uncovered and the truth will be revealed. Folks also asked me about Dylan Rounds. Dylan Rounds was a young man who had just graduated from high school and moved out onto a piece of property, very remote location, because he wanted to be a farmer. And he was doing some dry farming when he went missing. His body has never been found. He went missing in May of 2022. James Brenner, who was squatting on the property where Dylan was, has been arrested in the case. There was substantial evidence that he was responsible for Dylan's death, but Dylan's body's never been found. It's made even more difficult by the fact that the weather there is pretty awful during the winter. Dylan's family has been very diligently searching. They've also used some of the proceeds from some donations to make a donation of a high-powered drone to a search company. I think it may be Equus out of Texas, for use in these kinds of cases. Now, what we do know is that Dylan's telephone was found in a body of water, a retention pond, I think. And law enforcement was able to recover information off of his phone, even though it had been in water. And one thing that they discovered was a video of James Brenner covered in blood and cleaning his gun. So I think everyone believes that Dylan is dead, but his body hasn't been found and there's no concrete evidence. James Brenner was arrested for his murder, and he had a recent court appearance that was postponed, and his next court appearance will be November 13th. So we'll follow up on that after that court date. Now, we had a pretrial conference in the Daybell case, and there were some things worth talking about that came out of the case. And one thing that's a little bit of a mystery still. So the hearing happened yesterday. It was held by Zoom. Lindsay Blake and Rob Wood were there along with John Pryor by Zoom. Chad Daybell was there by Zoom. A lot of people remarked that he was very still the whole time he was there. It was a lot of people wondered if their computer was glitching because he was so still. So the first thing that the judge wanted to talk about was jury selection and how that was going to work, when they were going to start jury selection, when they were going to start handing out jury questionnaires. Now, you may remember in Lori Vallow's case, they handed out jury questionnaires early, had the jurors complete them and bring them back in. So jurors got a jury summons. They came to the court as they were summoned, and they were given a jury questionnaire, fairly lengthy, for them to take home, complete, and bring back. That was the jury questionnaire served to weed out a fair amount of people who, for whatever reason, were not available or not appropriate to serve on the jury. Narrowed the field down considerably. So they intend to do that again with the Daybell case. And in the Daybell case, they're talking about it being perhaps as much as a 2-week process. In Lori's case, it took about a week. But in an abundance of caution, I think they're leaving 2 weeks. As Lindsay Blake pointed out, it's still a death penalty case. And so there are other precautions and other questions that need to be asked of potential jurors, screenings that need to be done in that case that weren't necessary in Lori's case because the death penalty was dismissed. So they're allowing 2 weeks for that. So starting on March 18th, of 2024. Jurors will be summoned and receive their juror questionnaires, and then will be required to return them within the week so that jury selection can begin the following week. They're aiming for an 8-week trial with testimony and evidence starting on the 1st of April. So the court didn't make clear whether that 8 weeks took into consideration that if he's found guilty, there will have to be a penalty phase. So it's not clear whether that 8 weeks includes a penalty phase, but I would expect a penalty phase to take a couple weeks. So we could be looking at a 6-week trial and 2 weeks of penalty, or we could be looking at an 8-week trial and 2 weeks of penalty. And 2 weeks ahead of that for jury selection. So we could be looking at as many as, if I just did that math, quick math in my head correctly, about 14 weeks. A lot of folks have asked whether or not I am waiting on my book until Chad's trial is done, and the answer is no, that we are moving full steam ahead. I don't believe that there's going to be such different evidence presented at Chad's trial that would make it make sense to delay my book coming out. So we're charging ahead, full steam ahead. And it's possible that we may be doing some updates. The book itself is not scheduled to hit the shelves until September 2024, with pre-sales starting at CRIMECON in May of 2024. So once Chad's trial is over, we will have a little bit of time to do any needed updates. The judge also talked about motion deadlines and deadlines for discovery. They talked about when expert witness lists would need to be provided, when discovery would finally need to be provided, and John Pryor took a little bit of a shot at Jim Archibald and John Thomas in Lori Vallow's case when he said he will be, unlike the prior case, he will be putting on a defense, and made clear it would be a vigorous defense. So he said he's got several experts that he plans to call, and he also confirmed for the court that they are not doing additional DNA testing. Now, you may recall when Lori was getting ready for trial, one of the issues that came up in the discovery that was produced late was the issue of the late discovered DNA, and the fact that the prosecutor had worked with a commercial lab out of state to try and get all those results. And John Pryor said, I still need time to have my own expert review that data and determine whether I will need additional DNA testing. So after consulting with his expert, he determined that there would not need to be additional DNA testing. Now, Lindsay Blake reported that to the judge and made it sound like, gosh, Your Honor, we're very frustrated because now we have to bear the expense of a second Daybell trial because Mr. Pryor said that he needed time to do all this additional testing, and now he says he's not going to do the testing. And John Pryor was quick to point out that that was really not the reason why the cases were severed. The cases were severed because the prosecution delayed past the deadline getting discovery to the defense. And because of that, the defense did not have time to do the investigation that was necessary to prepare for trial. Part of that was the late discovered DNA, but there were also hundreds of jail calls. There were also videotaped FBI interviews that were never turned over. There were several pieces of evidence in addition to the late discovered DNA that were that were turned over late. Now, Lori's attorneys did not object and allowed all of that information to come in, including the fact that the late discovered DNA was one of Lori's hairs, and it was in the tape on JJ's body. However, that was because Lori wasn't going to waive her speedy trial, and there was really nothing they could do about it. So the prosecution told the court that they're filing 3 motions that they believe will be ready by either late this week or early next week to be filed, and that they will need hearings soon. The judge did say, Lindsay Blake brought up that during the last hearing, the judge had set aside a NF Mom, this is a good question. We're going to get to it really shortly. Sorry, I just caught my eye in the chat. Lindsay Blake said they are going to be filing these motions. Now, she asked that the court set aside a day a month so that they don't have to scramble to try and get a date if, in fact, there are motions to be heard before the trial. And I think that's a good. I think that's a good idea on the part of the court. She said the court did that last time, although we weren't privy to that. But they were able pretty quickly to get dates on the calendar, and that probably was because they had that time already set aside. Makes sense. So the judge said he would do that. Now, the last thing that came up was the issue of cameras in the courtroom. Now, you might recall that back when Lori's attorneys, I had to get the right players out there, when Lori's attorneys filed a motion asking the court to revise their order and ban cameras in the courtroom, Chad Daybell's attorney opposed it and said he wanted cameras in the courtroom. So the judge said he was going to take that up again, and that as far as we know from the hearing, both the prosecution and defense said their positions had not changed. The prosecution does not want cameras, and John Pryor and Chad Daybell do. They want a public trial. So the judge decided to set the issue out for a day-long hearing on November 28th in Rexburg. That will be an in-person hearing, not a Zoom hearing. And so he, in Fremont County, in St. Anthony. So John Pryor said he would be there. Everybody's going to be there. And the judge said to Lindsay Blake, if you have these other motions that you want to have heard, that would be the day to hear those. She said, we're going to ask for an earlier hearing on the motions we're filing. However, John Pryor said, my November is really backed up with other business, and I may not be able to accommodate an earlier setting. But we do know that on November 28th, there will be a hearing in Fremont County on the issue of cameras in the courtroom. And I think the big deciding factor is going to be Chad's desire to have a public trial. I think that the judge may feel like he doesn't really have a choice, because it really is up to Chad to decide whether or not a public trial is going to be the fairest way for him to receive a trial. So that will be a really interesting hearing. I'm contemplating going, not sure yet, but contemplating. So the cameras in the courtroom was the last thing that they discussed. However, here's the surprising part. When the hearing was over, and the prosecution said, we don't have anything further for the court. The defense said nothing further. The judge said, I'm going to take up an ex parte matter with Mr. Pryor. He has requested an ex parte hearing, and the matter is appropriate to have an ex parte hearing. So I am going to take up an ex parte hearing with Mr. Daybell and Mr. Pryor. Now, let's drop back and talk about what an ex parte hearing is. Ex parte means one party, and it means that only one side has to be there. And there are some reasons why ex parte hearings are held. They're held in a couple of instances. Sometimes it's a scheduling matter. It's just, I need the judge to order a hearing to be held. In that case, you can go to a judge ex parte and say, Judge, here's my request to set a court date on this matter. Please set a court date. Once the date is set, we'll notice the other side, and those orders are usually done with just one side. There are a couple of other ways that ex parte motions happen. One is Family Protection Act orders, so domestic violence restraining orders, stalking orders, those sorts of things are awarded when only one side is there, because they want the person asking the court for the restraining order to feel safe when they come to court and ask for it in a family abuse situation. The last reason is the reason we saw in Lori Vallow's case, and because it is not common in a criminal case for there to be any ex parte actions. So think back to where we got an ex parte motion in Lori's case. We got it when Mark Means filed a motion with the court telling the court that he had concerns about Lori's competency. That was an ex parte motion. That was a motion that was made by Mark Means. He presented his evidence to the court in the form of an affidavit. They had a court hearing with just the defense. And once the judge said, I believe that there is reason to be concerned, and I'm going to order an evaluation. And at that point, then the prosecution was brought into the loop, that there was going to be an evaluation ordered. The evaluation was provided to the prosecution. They agreed that, in fact, that there was a basis for a competency issue, and she was found to be not competent and sent off for treatment. That's when we saw an ex parte motion. So remember that the things that are kept private in a case are things having to do with medical or mental health. So I'm suspicious. Now, I just saw the question in chat. Is the reason Chad was so still because he's medicated? I don't know, but I NF mom, I don't know, but it's possible. It is not all that unusual for people who may have mental health conditions, and we don't know about Chad because we've never been told any of that information. But it is not unusual for someone who is in the situation where they are in pretrial custody. It's not unusual for them to decompensate and to melt down. So we don't know. It could also be a medical condition that isn't mental health related, because HIPAA protects a person from having to disclose to the court a medical condition, to disclose to the other side. It could very well be that a court order is required to transport him someplace for medical treatment. it doesn't necessarily mean that it's a competency issue. It could also be a physical illness that is requires him to be moved from the jail to some kind of medical treatment. We don't know. And I suppose at some point we will find out if suddenly there are transport orders and those sorts of things happening, we'll find that out. But I thought it was very interesting that the only other time that we have seen an ex parte motion has been the motion having to do with Lori's competency. So that definitely got my antenna up, my little antenna up. And I thought it was interesting that when I was sort of looking at what other people were saying about the case, nobody else really copped to it. So we're all in on it. And I thought it was weird. So we will be looking, we'll be following closely what's going on with Chad, and we'll be following closely what happens on the 28th of November. And I cannot believe that we are already in October and we're already thinking about the 28th of October is after Thanksgiving, believe it or not. It seems like this year has flown by. But I guess I say that every year. And I guess the older we get, the quicker they fly by. It was a great year for me with a wedding and writing a book and a lot of really exciting things happening. So I hope it's been a really great year for you all as well. Let's talk about YNW Melly, because this case is bonkers. I am telling you what, in all of my years, I've never seen anything like this. I have watched several of the other lawyers online who are saying this is crazy. In the military, we used to say it was knocking butts. This is a crazy, crazy happening. So for those of you who aren't familiar with the case, it's a case out of Florida. And YNW Melly and he was part of a group of guys who were a rap band, and they were just kind of at the point where they were sort of catching on and starting to make some money and getting popular. They'd sort of broken out of just being a local band and were achieving some success. They left a recording session. They all got in a car. They drove away. There's cameras security cameras caught them getting in the car. And then at some point later, two of the people who are in the car are shot badly and die. One survives his wounds, and YNW Melly is unscathed. And he claims that it was a drive-by shooting by some sort of rival group, because they are their rap persona is very much linked to gang activity, and there was some suggestion that they might have had gang affiliation themselves. So the trial itself was crazy. There were really interesting characters that were involved in the case, including an ex-girlfriend and her mother. And I mean, it was a wild case. There was an accusation that Melly was attempting to influence witnesses, that he was interfering with this ex-girlfriend and her mother, and trying to influence their testimony. So there was a prosecutor who was assigned to investigate these allegations of witness tampering. And so she sat down with the mother of the girlfriend and the lead detective on the case, whose name is Mark Moretti, and in a small conference room, and they sat down because they were going to interview this woman about whether or not there had been this witness tampering. And they had gotten a a warrant for her telephone. However, they were the deputy Moretti was out of his jurisdiction, so he actually didn't have authority to serve the warrant, and the deputy DA didn't either. The prosecutor didn't. So they were waiting for a local deputy to come and serve her with the warrant so that they could seize her telephone. So she's in this interview, and she digs through her purse and pulls her phone out, and she starts pushing buttons on her phone. Now, this is described by the prosecutor who was in the room with them. She's trying to push buttons, and Moretti keeps saying, stop pushing buttons, don't turn your phone off, leave your phone alone, you don't be deleting things, leave your phone alone. And she just keeps doing whatever she's doing, and the prosecutor doesn't know what she's doing on her phone. All she knows is that this woman is pushing buttons on her phone. And finally, Moretti reaches over and physically takes the phone away from the woman. There's a little bit of a scuffle. She doesn't want to give it up. Moretti gets the phone away from her. So later, after the interview is over, the deputy who has arrived to help with serve the warrant arrives. Now, Moretti's already got the phone in his hand, and he doesn't want to give it back to her because he's afraid she's going to destroy evidence. So he looks at the deputy now, but he seized it without a warrant. So he looks over at the deputy and he says, if anybody asks, you served that warrant. You were here and you served the warrant. Well, the prosecutor's eyes just about bug out. She wants nothing to do with this because that is absolutely illegal. The warrant is the woman, what the seizure of the phone was warrantless. They didn't have a perfected or a good warrant at the time that he seized the phone. So the seizure was illegal. And so he's telling the deputy, you better back me up and tell people that you served the warrant before I took the phone. And the concern was that Melly had been texting back and forth potential threats or potential telling them what to say back and forth. And so they wanted the telephone to be able to confirm that. So the prosecutor who had been in the interview went directly back to her office and went directly to her boss and said, this just happened, and I need to have this on record. I need there to be an investigation because this guy's the lead attorney on this case. And if it's proven that he's out there suborning perjury, basically, the whole case is going to come apart. So the boss says, I'll look into it. Now, this is an area where the district attorney, the prosecutor's office is large. It's a big area. And so she then follows up to her boss, and her boss goes up the chain, and she's not going to let this die. She is very concerned that Moretti is not only compromising this case, but if he gets compromised, he's going to compromise every case he's investigated. So it goes up through the chain, and she finally gets somewhat fed up with the fact that she can't make any progress about this. And she believes that she needs to file a Brady motion. She needs to let the defense know that there's this potentially exculpatory information because it undermines the lead detective's credibility. So she prepares a Brady motion, Brady notice, which is a notice to the court and to the defense saying there is this evidence out there, and it's to protect the prosecution from the defense saying you didn't tell us this. So she prepares the Brady notice, and somebody above her stops it. And it kind of goes back and forth, back and forth. Finally, the Brady notice goes out, and she CCs the defense to make sure that they know. And the defense then files these. By this time, the trial is over and there's been a hung jury. And so now the defense is filing motions to dismiss the case, to get Moretti off the case because of this, because of all of this wrongdoing. So the judge calls a hearing, and the prosecutor who was in the meeting with Moretti and the mom comes to court, testifies, tells the judge what happened, tells the judge what her concerns were. However, the prosecutor, when the court set the hearing, the defense subpoenaed the lead prosecutor on the case. They wanted her to come and explain to the court what happened, and she didn't show up. Instead, her office filed a motion to quash the subpoena. So as they went along, the judge finally said, look, this is this woman's case. I don't know why she's not here, but she better get here. You need to get her here. So her office then got her there, and she came and testified. Unlike the prosecutor who brought this to the court's attention, she was a little smug, a little cocky, a little defensive, like, how dare you question me? And so the judge decided that he wanted to have a full hearing on the issue. And now the defense has subpoenaed all of the prosecution team and the elected state prosecutor who is everybody's boss, because there's evidence that it went all the way up the chain to him, and he knew about it, and he did not demand that Moretti be pulled off the case or that he face some sort of discipline. So now the trial has been delayed, because the trial was due to start, I think, next week. So the judge has delayed the trial and is now going to dig into whether or not this detective Moretti is dirty. There are a lot of ways a cop can be dirty. It's not just taking a bribe. A dirty cop is somebody who goes out of their way to make their case, even when they don't have the evidence. If that means planning evidence, if that means making other people lie for you, that's what they do. And frankly, we don't have any room in our system for those kind of cops. So I'm hopeful the judge is going to at least tell them that they have to that they have to make that information known at trial, and allows them to bring that information in at trial, because it goes to impeaching the law enforcement officers that were involved in the trial. And I think Moretti's on his way out. I think because here's the other issue. Every case, once a police officer is proven that they've lied, and once they're caught in a lie of this kind of proportion, where they're so sorry, they're lying to make their case better, and they're actually falsifying evidence by illegally seizing a telephone, then offering the telephone as evidence when it was illegally collected, and then telling somebody to lie about it. When that happens, then the defense is going to suddenly challenge every case that Moretti's been involved in. They're going to go back and look at every case Moretti's been involved in for his entire career. And they're going to go back, and you're going to see appeals come back. Appeals come back on long ago convictions, because they're all going to be saying, look, if Moretti lied in this case, how many other cases did he lie about? how many other convictions are there out there that were based on lies? And so that means that this opens up this huge, huge Pandora's box, because everything is going that Moretti has touched is going to end up being suspect. So it's a really big deal. It was interesting at the hearing. The judge was kind of standing there with his arms crossed. And at one point, the defense attorney said, "Your Honor, you're standing there with your arms crossed, sternly looking at me like we started this, like it's our fault. And it's not our fault. This is clear malfeasance on the part of the prosecution as well as law enforcement, because the prosecutor covered it up. Well, she came to court and said, oh, Moretti just said it and he was only joking. But as the judge got into it, the judge found out that it wasn't Moretti who said he was joking. It was the deputy who Moretti had kind of strong-armed into lying, who said he thought he was being facetious. So it's going to be really interesting to see. Oh, I was told I use the word interesting too often, so I'm going to try not to. It is going to be very enlightening to see what happens in this case, but it could have huge ramifications. It could impact whether or not the Melly trial starts next week. So I think we're in that one. That one's juicy, and we're in for a bit of a roller coaster on that one. And you know, I mean, when I was practicing, we had an instance where we had someone who was a state crime lab employee who was caught falsifying records, and it had to do with potentially taking drugs out of the lab and falsifying results. And it ended up being a huge can of worms, because for the next year, then every defense attorney in the state was reviewing all their cases, finding out whether or not that particular lab technician worked on their case, and filing motions to have judgments of guilt set aside. And, you know, I mean, in that case, if you have a case where you've got a drug case and the police sees a sample and it goes to the lab and the lab tests it. If the lab says, yes, this is meth, then you have a conversation with your client about, okay, well, the lab says the substance they found in your pocket was meth. We should really talk about a plea. However, if you have relied on those results in order to have that conversation with your client, even a guilty plea could be at risk. So it will be fascinating to see what comes up next. Now I want to talk about the Ferrier case. Ferrier is a case out of Florida. Now, last week we talked at length about a couple of cases that involved child welfare and involved children. We talked about Gypsy Rose Blanchard, whose mother was causing the world to believe that she was sick because of Munchausen by proxy. And then we also talked about Maya Kowalski, whose mother committed suicide after the family was accused of Munchausen by proxy when the child actually had a valid medical condition. That Maya case is still ongoing. There is an ongoing civil case going on right now where the family is suing Johns Hopkins Children's Hospital over their treatment of Maya during that time. The Ferrier case is a little bit different, and I want to talk a little bit about this. Their son was a child who was adopted and was one of those children who was warehoused um, and in an orphanage and was not properly cared for. We know that those children um, have horrible early life trauma, and it leads to them having very serious mental health problems, including something called reactive attachment disorder. So, reactive attachment disorder is very common in our ability to attach to our caregivers and to our family members develops very early in our lives, somewhere between the ages of birth and 3 years old. So this child was adopted at around a year and a half to 2 years old. And until that time he was malnourished. He had been warehoused in a sort of industrial orphanage with very little care. And because of that, these children often have very severe mental health issues. He's adopted by the Ferrier family, and they have 4 children. I'm not clear at this point if they're all adopted or how many of them might be adopted, but it becomes clear to them that this boy is a danger to potentially to himself, but to his siblings as well. He's exhibiting frightening behaviors. He's 10 or 11 years old. He's taking knives to school. He's abusive to the other kids in his school. There's a lot of very troubling behaviors. Children with reactive attachment disorder have some very, very specific kinds of behaviors. They often cannot control their anger. They often have issues around food and eating. They hoard food or they won't eat. It's like a control issue. They've gone hungry, and so now they hoard food. It is a very well understood condition with children who have been subjected to neglect and trauma in their early formative attachment years. So the family was living in Arizona. In Arizona, they were having serious problems with him, and they built a cell essentially in their garage. And it was a secure place for this boy. Now, there's a lot of discussion about whether or not this boy was kept in this cell, whether or not he was sent there when he was having behavioral issues, how much time he spent there. But it's clear that that was never a good alternative, but the parents did it. They felt like they didn't want him to end up in state custody. They didn't want him, and they were trying to keep him from ending up in a locked facility. And they were trying to keep him from hurting anybody else. They went about it all the wrong way, but that is their contention, is that they had this extremely dangerous, very difficult child. And instead of seeking help and trying to get someone to give them some assistance, they used their own self-help, and they locked him up to keep everyone else safe. The real big issue in this case, so the father has been charged with child abuse, basically. And the mother has also been charged, but she's not on trial. They're being tried separately. So the father is on trial. And the real issue is whether or not the prosecution can prove that they did this maliciously, that they did it out of malice. And it's unclear at this point whether or not the prosecution has proven that case. As I say, it went to closing arguments today, and so we should be getting a verdict in the next day or so. But it's a difficult question. Clearly, these parents went about helping this child in all the wrong ways. Some of the things that are troubling are the fact that when they moved from a home in Arizona to Florida. And when they bought their house in Florida, they had another cell built in the garage. And they actually bought a house with one less bedroom because they didn't need it for him because he was in the garage cell. The father also had someone come and build this room in the garage and told them that he was going to use it as an office and that it needed to be secured. When the guy put the lock on the door, he had them turn it around so that he could bolt it from the outside rather than from the inside. And he told them that he was going to be using it for an office. It does suggest some consciousness of guilt, knowing that what they were doing was wrong, because they lied about what they were going to use that structure for. Reactive attachment disorder is a very difficult condition to treat, depending on the severity of the condition. I, of course, represented children who were in the state system with a variety of conditions, including kids with reactive attachment disorder. Typically, what happens is like this family, where they have adopted a child, not understanding how incredibly damaged these children are. And they get these children, and 5 or 6 years later, they begin exhibiting all of these horrible, violent behaviors. And so these families are often so far down the road with these children. These are their kids. And now they're having to figure out what to do with this child who's completely gone off the rails. So, this kid was running away. He was giving beer to his 4-year-old sibling. He was hurting people at school. He was engaging in a lot of really dangerous and troubling behaviors. So, yeah, I mean, it's easy to sit back and say what these parents did was wrong. They certainly dealt with the problem improperly and probably made it much worse. However, I also, having worked with these sorts of families, understand how limited the services are and how limited the alternatives are for these families. So it's easy to say this kid needs to be in treatment. He needs to be in a secure facility. He needs to be with highly trained professionals who can help him. It's much harder to find that bed for that kid. And kids sometimes wait months for those sorts of therapeutic treatment beds. In the meantime, what do you do with this child who's a danger to himself and to other people, and clearly to his siblings? So it is a thorny case. And I have no doubt that these people who went out of their way to adopt a child who needed a home seem to have had their heart in the right place. They simply got overwhelmed and were not equipped to deal with a child that was experiencing this level of damage. And it is difficult when you adopt a child through an agency and they hand you this baby, and this baby is now your child. and you see these things emerge, and you're working on them, and you're trying to parent this child, and then suddenly this child becomes like a monster. And I don't mean to be overly dramatic about it, but you can't overemphasize this. I mean, I worked with families where their two little boys that they adopted when they were 2 and 3, and they were the most adorable, loving, darling little boys, turned 11 and 12 and lost control completely, and ended up, both of those boys, in locked facilities. And in one case, the one boy ended up having to be heavily medicated and physically restrained from injuring himself or anyone else. It's not, there aren't simple answers for it. And there aren't resources available in the community to help parents deal with these sorts of issues, and that you're out there floundering alone trying to tread water and keep everyone safe. I guess I can understand why they chose this route. They didn't want to give up on the kid. They didn't want to turn him over to the state and say, take him. They didn't want him in some sort of suspect lockdown imprisonment facility. They wanted to still be able to have some control over trying to get this kid to understand and to conform his behavior. So I there's no question. I mean, his defense attorney says, my client went about this completely the wrong way, and probably in the process did more damage to his son, but he didn't intend it. And so the issue is intent. Did the father intend to impose or do harm to the child? Did the father intend to abuse the child? And so that one is going to be interesting to see what the jury does with it. And so we'll be waiting, probably have something to talk about next week about this case. There are a couple of other cases that I want to just touch on really briefly, and then I want to talk a little bit in depth about the Karen Reed and John O'Keefe case, because that one is one that I'm a little interested in. So I want to talk a little bit about Ellen Greenberg. Ellen Greenberg is a woman who was found and deceased, and her death was ruled a suicide, even though her body had many stab wounds, including stab wounds to the back of her head and stab wounds that were that the coroner, the medical examiner ruled were clearly postmortem. So there are a couple of creators out there, including Joel Waldman from Surviving the Survivor and Gigi from Pretty Lies and Alibis, who have really been digging deep into this case because they have been trying hard to get her case reopened. It appears that this may be another YNW Melly case. It may be a case where there were some shenanigans going on the part of law enforcement and prosecution. So that one is going to be one to watch. If you are at all interested, her name is Ellen Greenberg, and both Joel at Surviving the Survivor and Gigi at Pretty Lies and Alibis have covered it extensively. Gigi's been doing a deep dive into all the documents. So if you're interested, definitely take a look at what Gigi's been doing. There was a hearing in the Markel Adelson case. Markel, this case is the Florida State University, FSU. right, Florida State University law school professor. He was a Harvard law grad who was murdered. His ex-wife's brother is in custody and ready to start trial in the near future for a murder for hire plot. The two people who were the gunmen who were responsible for pulling the trigger and gunning him down in his driveway were convicted, as well as the woman, Katie Magbanowa, who was the brother's girlfriend who arranged it, was the go-between between the shooters and the brother. The whole dispute was over a custody battle. Wendy Adelson was divorcing Dan Markel, and they were arguing over custody of their two children, mostly because Wendy Adelson wanted to move from Tallahassee, Florida, to the Miami area where her family was. And Professor Adelson opposed that because he didn't want to be that far away from his children. And the judge had ordered that the children had to stay in Tallahassee, and that if she wanted to continue to have the kind of parenting arrangement that they'd had, which was sort of a 50-50 custody sharing, that she would have to remain in Tallahassee, which she hated. So it is alleged that her brother talked his girlfriend, Katie, into finding these two guys to pull the trigger. And it's also alleged that Wendy Adelson's mother, Donna, was also involved in the plot and plotted with her brother, Charlie, Donna Adelson's son, Charlie. So there were a few important rulings that came out of the court because they're getting close to trial. That trial starts on the 23rd of October. And the court there were some wiretaps that were done that trapped conversations between Donna Adelson and Charlie Adelson, the mother and son, as well as a recording that was done between Charlie and Katie Magbanowa. It's a hard one to say. And in a restaurant that was captured. And these were pretrial motions in limine, asking the court to make pretrial evidentiary rulings. So the judge is still considering the issue of the wiretaps, but the wiretaps came in both the other trials that have already happened of the co-conspirators. So it's likely that they're going to come in. The judge did allow the recording that was done in a restaurant to come in. There was some dispute about whether or not it could come in because it had been enhanced by a sound engineer. The defense didn't want all of the divorce records from the Adelson-Markel divorce to come in because it was a very acrimonious divorce, and they wanted to try and keep those records out. The judge said they come in because they prove motive. There were some things excluded, including a comment that was made by Donna Adelson to another one of Charlie's girlfriends, and saying that she felt like Dan Markel was haunting her from the grave. And the court ruled that that couldn't come in because it was hearsay, because it wasn't said in the presence of one of the co-conspirators. It was just between Donna and the girlfriend. And Donna has not been charged, although she has been named as an unindicted co-conspirator. But that doesn't count for it coming in under a hearsay exception as a statement of a co-conspirator. One of the big issues has been that they have been attempting to get Donna Adelson, the mom, and her husband, the father, Harvey Adelson, in to be interviewed by law enforcement. Now, in Florida, it's kind of interesting. Law enforcement can grant immunity to people in return for them coming in and freely being interviewed and answering questions. And they've offered that to the Adelsons, but the Adelsons have declined to come and testify. So the judge ordered them compelled to sit for investigative interviews. And that is going to be decided on Thursday, tomorrow. So there has been that issue of whether or not the judge would compel them to sit for those interviews. I expect the judge is going to order it. However, we'll know tomorrow. So an interesting little piece of juiciness. Rex Heuermann, who is the alleged Long Island serial killer and is in custody currently, has a new pen pal, and that pen pal is can't think of his first name. His last name is Jesperson. He was the happy-faced killer. He was a truck driver who traveled all over the country, but a lot on the West Coast. And he actually is in prison in Oregon, where he was convicted as a serial killer. He's been writing to Heuermann and telling Heuermann, giving him advice, which I think is really interesting. Other folks thought it was interesting too. He was known as the happy face killer. His daughter was involved in a really interesting podcast, which I have put in my show notes about the happy face killer. It's a fascinating story, and if you are at all interested in it, you can find those a link to those podcasts in our show notes. The last one that somebody asked me about is Jonathan. I'm not sure whether it's Quillis or Quiles. However, he was convicted of murdering a 16-year-old pregnant niece. The interesting quirk about this is that shortly before his trial, this is a case where he was involved with his niece. She was 5 months pregnant with what authorities believe was his baby. She was 16 and she disappeared. Her body's never been found. They believe that he put her in a dumpster and that the body is in a landfill. They extensively searched the landfill and were unable to find it. The interesting little quirk to this one from a legal standpoint is that Florida changed their death penalty law recently. And what they decided was that the decision to impose the death penalty, so the penalty phase of the trial, did not have to be a unanimous decision. It could be a decision of 8 of 12, or 3/4 of the jury, 2/3 of the jury. And so now there is this discussion about whether or not he gets a new trial because of the upcoming, because of a challenge to whether or not he required a unanimous jury. So that is up on appeal. And likely will go to it's up on the appeal to the state appellate court, and that likely will take quite some time. Now, I do want to talk a little bit more in depth about Karen Reed and John O'Keefe. I know some of you have been following this case quite closely. It's a case out of Boston. Karen Reed and John O'Keefe had been boyfriend and girlfriend for a couple of years. John O'Keefe was a police officer, a Boston cop. He was raising his young niece and nephew after his sister died of a brain tumor, and her husband died because of all the stress of a heart attack shortly after the sister. So Karen and John had been dating for about 2 years. Karen had been very involved in helping him with these 2 children, and they seemed to have a pretty good relationship. She was an equity analyst and a part-time college professor. They went to a bar one night, ran into some friends, some people that they knew, including Brian Albert, who was another Boston police officer. And they all spent much time at the bar. When the bar was getting ready to close, Brian Albert invited them to continue the party at his home. Karen said she was hungry and tired and she really wanted to go home, but John O'Keefe said he wanted to go on to the party. So she took him to Brian Albert's home. She then decided that she would drop him off and that she was going to leave. She left and went back to John O'Keefe's home, fell asleep on the couch, and woke up at about 4:30, realizing that John O'Keefe had not come home. She started calling people, asking them if they had seen him, people who had been at Brian Albert's home at the party, people who'd been at the bar, and nobody had heard from him. So then she got help from a couple of other people. They got in the car and they started driving around looking for him. There had been a really, really bad snowstorm, a nor'easter had come in, and so there was a lot of new fresh snow on the ground. The roads were treacherous, but she drove around with these other friends, calling around, driving around, trying to find out where he was. They finally went back to the house where the party had been. And when they pulled up in front, she realized that he was lying in the snow outside the house. The authorities were called, 911 was called. First responders arrived, and he was clearly dead and clearly had died from the cold, from hypothermia. He also had a lot of injuries around his head, his arms, and she has made a variety of statements. At one point, she said, "Oh my God, is it possible I hit him? I backed into him. Is that possible?" I mean, she's made some irrational statements. She also admits that she was very drunk and that she does not remember a lot of what happened that night. And so following the investigation, she was charged with having with manslaughter and accused of having hit him with her car. She then began, she and her attorney began doing investigation, and her attorney began receiving tips that in fact, what had happened to John O'Keefe was he had gotten into a fight. Brian Albert had a nephew who John O'Keefe had sort of gotten crosswise with because the nephew was sort of a punk. And at one point he'd gotten into it with him, and that the nephew was at Brian Albert's home that night. And she believes and contends that he got into a fight, that they beat the tar out of him, and then they threw him out in the yard. One of the things that is a little bit suspicious is the medical examiner determined that he had an injury on his arm that appeared to be an animal bite, to be a dog bite. And in fact, Brian Albert had a German Shepherd that had been known to bite. And it wasn't out of the realm of possibility for there to be a fight breakout and for the dog to try and get involved. So there are some very unusual quirks to this case. she had a broken tail light on her car, which she was not able to account for. And so law enforcement has jumped to the conclusion that this was, that it was caused when she hit him. However, there is that there have been claims that the lead detective, sorry, I'm trying to read my notes here, that the lead detective, Michael Proctor, has longtime ties, a long-term relationship with the Albert family. He's the lead detective in the murder of John O'Keefe. He's got a long-term relationship with the Albert family and really probably has no business investigating the case. And certainly would be in a position to cast doubt on, or to protect the Albert family and to cast doubt on Karen Reed. In a kind of quirky little twist, there is a blogger who goes by the name Turtle Boy who has really taken up this case on behalf of Karen Reed. And he was recently arrested for witness intimidation. And he claims that the U.S. attorney, one of his claims is that the assistant, the office assistant to the U.S. attorney is trolling him. But he has been arrested for witness intimidation. So lest you think that all of these folks who are deeply involved in the true crime world don't have any impact on these cases, here's this guy who's actually been arrested for trying to influence witnesses in the case. He's unrelated to the case other than the fact that he is a true crime blogger. He got interested in the case. Apparently he was a big-time, well-known sports blogger and got interested in this case, has taken up on behalf of Karen Reed, believes that in fact she is being railroaded by the law enforcement community in Boston, and now has been arrested. So that makes you wonder, did he really attempt to intimidate witnesses, or is he getting too close to the truth and is law enforcement coming after him? Many questions and many things that make you go, So that is the end of my rant. I've been going for an hour and a half. My voice is about to give out, and it's time to take some questions. So let's chat. Hi, Polly-O. Wendy, the wife, looked very shifty, almost guilty on the stand. I could not agree with you more. Her body language looked downright shifty. And when they asked her about, it was sort of a deposition, and when they asked her a question about the possibility of her being arrested, she laughed at him and said, "Why would I get arrested?" It was really contrived, and yeah, she looked shifty. And I think the one who is the mover and shaker in all of it is Donna Adelson. I think the mom. This is another case. It has some striking parallels to a couple of other cases where child custody was on the line. This is another case, it reminds me a little bit of the Piketon case, the Piketon, Ohio massacres. Now, in that case, the mother and the father were fighting over the children, and the grandmother was so determined that she was going to control where her grandchild went that she got her entire family, her 2 sons and husband, to go out and murder 8 members of the mother's family, including the mother, so they could have the child. So now they're all in prison, and the mother's family is raising the child. So, and there's a lot of great information, a lot of great podcasts out there about the Piketon massacre. But I think there's a lot of parallels to it. I think Donna Adelson is the mover shaker. I think she's the one who decided that something had to be done because her grandsons could not continue to live in Tallahassee. They all needed to be close to home. And there's certainly some suggestion that she was overly involved in the lives of her children. She was very overly involved in Charlie's life, to the point where they talked 2 or 3 times a day. And it was a very unhealthy adult-child relationship. Hi, Polly. I have followed the Maya Kowalski case. In fact, we talked a little bit about it tonight. I talked at length about it in last week's case. We we talked at length about a couple of child cases, because when I was practicing, I was involved in representing parents and children in child welfare cases. This is a good question. This varies from state to state, and there are states where jurors are allowed to ask questions. I think we saw this in, I want to say we saw it in Letitia Stauch, but I could be wrong. But we recently saw a case where the judge would ask the prosecution and defense, do you have any other questions? No. And then would turn to the jury and say, do the members of the jury have any questions? And they are allowed to write their questions and give them to the judge. And then the judge, if the judge believes that they are appropriate, relevant questions, is allowed to ask those questions. So it depends on the state, but in some states, jurors are allowed to ask questions. And I believe in the federal system, jurors are allowed to ask questions. And judges take a much more proactive role in jury selection and in witness questioning in federal court. So, good question. Hi, Julie. My friend Julie has been a little under the weather, so send her some good juju, please. I hope she's feeling better. Have I heard how Pryor is paying for those several experts? I have not heard how Pryor is paying for his experts. Now, I will tell you that in complex cases, even in the instance where a lawyer is retained, the state does sometimes pay for experts in these kind of complex cases, because I think the state recognizes that even if a person has retained an attorney, they may not have the resources to pay for the kind of experts that are necessary to mount their defense. So it is sometimes the case that the state pays for those, even in a case where the defendant has not been declared indigent and has not and has retained counsel. But we don't know how Pryor's being paid. I suspect at this point he's not being paid. I suspect that he took whatever the equity was in the family home in return for his services, and they've agreed that that's sufficient for him. And Chad Daybell isn't employed. He doesn't have any other resources. So I suspect that the state may be paying for those experts. This is a good question, and it may come out at trial how the experts are being paid. I think it's a reasonable question in this case where we know that he doesn't have any resources, but people are allowed to retain attorneys and figure out ways to do that. So I think we're pretty sure that his neighbors didn't mortgage their house for him, because they weren't about to do it to get Lori out of jail. It always amuses me that he had the temerity to go to his neighbors and ask them to put their house up to get Lori out of jail on bail. So, and they were good friends of Tammy's. That takes some cojones to go to one of Tammy's really good friends and say, could you put your house on the line so I can get my new hot wife out of jail? Julie, I hope you're feeling better. Connie, Chad has always been a statue. Could it have been something with his children? This is a good question. I don't believe that anything having to do with his children, because they're all adults, would have justified an ex parte hearing. So it's possible that, something could have come up that the court needed to rule on having to do with his children, although I can't think of anything right off. But I can't imagine that it would be appropriate to bring an ex parte motion for anything other than something having to do with his own personal privacy. So either mental health or medical. But Chad has always been very still. One of the things that I've noticed as I was writing my book and I was watching for Mary Howard says, I heard Pryor ask the state for something like 180,000 for experts. That wouldn't surprise me. One of the things I noticed while I've been working on my book, I was watching some of the old interviews and the police interviews from Arizona with Lori. And she was like freaky how still she was. She was absolutely like a statue. And the only reason that you could tell that the video was still going on was because you could hear kind of muffled next door the voices of Tylee and the interviewer next door interviewing. But she sat there like eerie still. So I don't know. I don't know if that's a prayer thing or I don't know. But he does tend to be very still. I also noticed he looks thin. He looks like he's lost weight. So how are you, Ladybug Lady? I love your little ladybug emojis. Could the private hearing with Chad be for him filing for divorce? Just wondering. I don't think so, because divorce is a public procedure. I mean, it's a public filing. So I don't think so. If Chad wants to file for divorce, his lawyer would file a divorce petition with the court and Lori would be served and it would go forward just like anybody else's divorce. It wouldn't be a private hearing. It wouldn't be a private matter. So I don't think so. I don't think, and one wonders what benefit a divorce could have at this point. I mean, I don't know that there's any downside to it other than that it would draw a huge amount of attention and probably cause her to flip on him. Because she's 100% all in on him. We don't know whether he's still 100% all in on her. We don't know for sure. But it's pretty clear she's all in on him. And he certainly doesn't want to file for divorce and have her be the spurned woman and flip on him. So I wouldn't expect, if he's going to divorce her, it will be after his trial. It will not be before. So good question though. I mean, the only thing that I can think of is something that he has a privacy interest in. So it's got to be mental health or medical, I think. So good question though. What kind of experts do you think Pryor would use for the defense? This is a good question. He's certainly going to use his DNA expert. He's already got that guy, and he's a heavy hitter. So he's certainly going to be using his DNA expert. I think he's also going to be calling experts to talk about Lori's influence on Chad in terms of her mental health. So I think he's going to call experts who are going to say, yes, Lori was crazy. How does Lori's mental illness how does her mental illness play into how she manipulated him? So I think that may be one of the experts that they're going to call. And I think there will be some experts to talk about the GPS and the cast electronic data. I was trying to put it in the simplest terms. I have seen in articles that I've read recently about evidence in general, scientific evidence, there have been challenges to the cast process. And I am not a mathematician by any means. I am not an electronics expert. I don't really understand all this. But what I do understand is that the way that the cast system works, the cast system pinpoints a location and can do it up to a matter of within feet. So they were able to show, the cast data was able to show that Chad and Alex or Alex was near JJ's grave, and Alex was near where Tylee's body was disposed. And there's been a lot of question about the accuracy of the cast process because it uses raw cell data. What they do with it then is they use different formulas and different algorithms to predict outcomes. And so there are a lot of people who are now questioning whether or not those algorithms and those equations to predict outcomes of that data are accurate, whether those are the right formulas, whether they're the right ways to interpret the data. So it's being attacked. And I think that John Pryor is probably going to bring in an expert who's going to be able to the same way they did in Murdoch, is going to be able to draw into question whether some of that data. Now in Murdoch, they talked about, well, how could this person be, how could the truck be in this location when Maggie's phone was thrown out minutes before or seconds before? And there's a discrepancy on when the truck was driving by the location where Maggie's phone was and the data in Maggie's phone. So I think you're going to see experts brought in to call into question some of that data. Because we know that there are kind of nationwide, there are challenges going on to that. And then I'm certain he's going to have experts that are going to come in and talk about the viability of the death penalty and whether or not, I mean, that will come in certainly in the penalty phase, but you know, he has said he is going to mount a vigorous and all direction defense. And that is very unlike what happened in Lori's case. Now, we realize that in Lori's case, she tied her lawyer's hands. They really didn't have a lot to go on because she would not let them use the information that probably could have been the most helpful to her. So I suspect DNA, Lori's mental health, and the GPS cast data are going to be three things that would need experts. And I suspect the cast expert could be expensive because there's a lot of data to weed through. There's thousands and thousands and thousands of data points. So. My husband's calling for my mom's little dog to come and get treats. And he's in here with me and the door is closed. So he won't be hopping out anytime soon. He'll have to get his treats after we're done. Hi, Susie Gay. Question: how much of Lori's mental health can they bring in at Chad's trial? This is a good question. I think there is some of Lori's mental health that can be brought into Chad's trial. Now, one of the questions is going to be how much of what happened in Arizona is going to come in at Chad's trial? Because I think the place where you really get to I think the place where you really get to the origins of Lori's mental health issues is in Arizona. So it'll be a little interesting to see whether they are, how much of that they're going to be able to bring in Chad's trial. Now, because Lori was a participant in the events that happened in Arizona, it was easier to get in that information in Lori's trial. It's going to be harder in Chad's trial. So they're going to have to figure out whether or not and how much of that prior bad acts information, that 403B evidence they can get in. And because that, I really think that's where you can start to line up Lori's mental health issues that sort of predate Chad. Once you do that, then I think they can say, look, Chad was kind of a feckless guy. He, was sort of influenced by a pretty face. He believed everything she said. He was really gullible and she was really fabulous. And here we are. I think they're going to do as much as they can to put it all off on Lori and of course, Alex. So I think they're going to be able to bring some of that in as a way of saying, poor Chad had no idea. He believed her, and he had no idea that he was dealing with someone who had such profound mental health issues. He thought, he was dealing with a goddess, and it turns out he was dealing with someone who was just delusional. And so I think they're going to try and go there. How much of that evidence is going to come in is going to depend on the judge and how much he's willing to allow to come in. It is a little bit different because she is convicted and no longer just a co-conspirator. She's a convicted co-conspirator. So it'll be a little bit different, but I think these are the kind of things that I find interesting when I watch trials, is how judges decide and the reasoning that they use to get there. Lori's influence on Chubby was holding on to the storm. Yeah, well, we all know that. We all know that she led him around by the storm through most of all of this. But, he also was quick to step into the prophet role because that's what she wanted. He was quick to give her what she wanted and dive into it headfirst. So I think in some ways it was a perfect storm because I think they sort of led each other around. So. Hi, Julie. Oh, Tim Ballard. The Tim Ballard story is very interesting, and it is somewhat shades of Chad Daybell and Jody Hildebrand. And so I have been following it, and I sort of debated whether or not to get into it. But just very quickly, Tim Ballard is a member of the LDS Church. He has now been excommunicated, but and he was reportedly a CIA operative who left the CIA to found this organization that rescues victims of human trafficking, specifically children in third world countries that are being trafficked. There's always been some real question about his methods, because he would go into a local area, pose as someone who was looking for child sex workers, and then he would rescue them. Now, there is some dispute over how many of these people were actually really rescued. And some discussion about the fact that perhaps he's inflated his claims of how many people he's rescued. But he would put these teams together. And what did they call them? Jumps, I think. And he would put these teams together, and they would go into a third world country, and then they would try and bring out these child victims. And one of the things that he did was he often took, he's married and has 9 children, but he would often take these volunteers with him who would pose as his spouse. Because what would happen is, they would go into these places and he would pose as this person looking for a certain kind of action. And oftentimes the people he was dealing with would try and get him to engage in these behaviors as a way of proving that he wasn't a cop, or some show of good faith. And so he purported that he was protecting himself from having to do those acts, because he would say, oh, I can't because my girlfriend or my wife is here with me, but let's talk later, wink, wink. I mean, the whole thing is strange, and it doesn't necessarily make a lot of sense, and doesn't necessarily ring very true. So he claimed that he had the blessing of one of the apostles, who the LDS Church, the apostles are extremely powerful, and that he had the support and blessing of one of the apostles. He raises an incredible amount of money, and he does it primarily to people who are involved in the LDS Church. And so the church came out and distanced themselves from him. Some of the people who were on these jumps with him reported some questionable behavior. And the organization he founded, which is called Underground Railroad, I think, the organization drummed him out of the organization. He had to leave his own organization that he founded. But he was still doing this, and he was still doing fundraisers, and he was still, saying, I'm not going to give this up. And so they, the church then decided they wanted to distance themselves from him, and they wanted to distance their apostle from him. His books he wrote books. They were all carried in Deseret books. He spoke at all sorts of LDS events. He was a speaker at a lot of the same kinds of conferences that Chad Daybell was at. And so there are some parallels. One, just within the last day or so, over the last couple of weeks, it's come out that the women who went on these jumps with him claim that he sexually abused them, that he coerced them into sexual conduct, that he used coercion and grooming and all of those things to get them to participate in sex acts with him. And they filed a lawsuit. And in that suit, one of them claims that he said, the apostle said it's okay because we were married in a prior life, which sounds frighteningly like Chad Daybell. So there are a few little parallels and overlaps. Certainly Jody Hildebrand, she is the therapist who's been doing this tough love therapy, and is now under arrest for abusing Ruby Frankie's children. And certainly she was deeply enmeshed in the church. it's very clear that she was on the church referral list and that she was frequently, the church was frequently referring clients to her. Additionally, in the case of Jody Hildebrandt, because if a bishop refers someone to a therapist and they say, we'd love to, but we can't afford it, the bishop has just discretionary funds that can be used to pay those expenses for people. And so there's some suggestion that a very large percentage of Jody Hildebrandt's income came directly from the church paying her to provide therapeutic services to church members. So they're kind of thorny questions, and there are some parallels. It seems to me that in all three of those cases, these are folks who sort of espouse the most orthodox conservative branch of the LDS Church, those folks who really want to go back and they want to go back to the days of Joseph Smith and make sure that they want to take up some of the things that the church has since left behind because they no longer believe that they're appropriate. So there are a lot of folks who they're called Orthodox or neo-Orthodox that really want to sort of, they believe that the church is in its own state of apostasy, and that only returning the church to its true Reformed roots will return the church to its faithfulness. So it's very interesting, and I do think that there are some parallels to bring out. I think it will be. We don't know how the Tim Ballard story is going to play out. At this point, there are no criminal charges. They're all civil suits that have been filed. But there is a potential, I think, for some criminal charges to come as well, depending on how aggressive the authorities in Utah want to get, and how far out some of these things are outside the statute of limitations. But I do remember reading that Utah has recently revised their statute of limitations to make it easier for victims of sex abuse to report late, for there to be late reporting. So thank you. Hi from Pensacola. Oh, Trisha the trucker, you're in Pensacola. I have very fond memories of that area of the Florida Panhandle, a little bit south and down around Fort Walton Beach and Destin, that area. So so enjoy Pensacola, Florida. Stay safe, and you need to plan your trip. So in May, you're going to be in Nashville, because we want to meet you in Nashville. So, is it possible to sue Oregon child welfare? Yes and no. Suing child welfare can be sort of a thorny issue, because in most states, state agencies have immunity from suit. There are some instances where Oregon child welfare can be sued and has been sued. I had a good friend who used to pride himself on suing child welfare all the time. So it is possible, but you have to jump through some hoops, and there are some limitations on when and how and for how much. So, but if you are looking for someone to do that, reach out to me on email, and I can give you referrals to somebody who might be, I don't know if he's doing it anymore, but he certainly might be able to refer you to somebody who still is. I say I don't know if he's doing it anymore only because I think he's probably getting ready to retire, but there's always somebody out there who's happy to sue child welfare. Statute of limitations on suing child welfare? Yeah, you'd have to talk to somebody who does civil work, because I didn't do civil work. So you would have to talk to somebody about that. More questions? Well, we are coming up on the end of our 2-hour block. I want to thank everyone for being here. I did not take the time as the chat was flying by to thank the people, but I saw several. Arizona says Eglin, Tyndall actually, but close. Eglin, Air Force Base in the Florida Panhandle. I do want to thank everybody. I did see a number of really generous donations fly by in our chat, and I want to say on behalf of Michelle, thank you so much for those. We will do our best to keep you up to date on how Michelle is doing. She's got some good help, so I am hoping that she's going to do well. But doing cancer treatment and doing chemotherapy is never easy. We all know that. You all probably know that. A lot of you probably know that better than I do. So please keep her in your prayers. Please keep sending her really good healing thoughts. And I just thank you so much for your generosity for her. Be with us next week. If you have cases that you would like me to take a look at, please drop your comments in the, drop the suggestions in the comments, and we will get to them. And let me know if there are other cases you'd like us to talk about. I am very interested in the Adelson Markel case, and so we'll be keeping up with that. And I will be definitely keeping up on some other of these cases. I'm also very interested in Karen Reed and John O'Keefe, because that is another one of these cases that has the potential for being a case about law enforcement malfeasance and about crooked prosecutors and cops. So I stay tuned while we dig into that information. So I'm going to say thank you for joining us. Don't forget to subscribe and hit the bell if you enjoy the program. Don't forget to send in your raffle donation for this quilt on the wall. That information is in our show notes, and I will be plastering YouTube and Facebook with that information. So if you want a chance to win this quilt, be sure and get online and buy a raffle ticket or two. And we will see you next week, same time, same bat channel. And you all have a great week. Have a good weekend. And we will see you all soon. Good night.